All right, let's dive right in. Today, we are putting together the ultimate playbook for any aspiring barrister who's got the Queensland bar exam in their sights, or really, for anyone practicing commercial law. We're going to demystify the Supreme Court's commercial list and give you that strategic edge you need to walk in there with total confidence.
So if you're in the thick of prepping for the bar, you absolutely know that procedure can make or break your case. This isn't just some dry, theoretical stuff. Nope, this is your practical guide to one of the most important arenas for commercial disputes. We're going to walk through the key practice directions so you have the advantage. You see this sentence? Everything, and I mean everything, starts right here. This is the why behind every single rule we're about to talk about. The whole system is built on 4 pillars: being just, fast, efficient, and cheap. Every move you make on the list is going to be judged against this one standard. Remember it. Okay, so first things first, how do you even get your case onto the list? Your opening move is absolutely critical. Let's break down what kind of cases make the cut and the process for getting in the game, which is actually surprisingly simple. You might be wondering what a commercial matter actually is. Well, the definition is deliberately wide to keep up with modern business. We're talking everything from old-school business contracts to cutting-edge disputes over crypto and data security. The rule of thumb is, if your case pops up out of trading commerce, it probably belongs here. The process itself is built to be easy. It's basically 3 steps. Send a request, fill out a form, and then you get your allocation. Now, that last step, that's the game changer. A single judge gets assigned to your case from the very beginning to the very end. That is a massive strategic advantage. It means consistency and a judge who knows your matter inside and out. So you're on the list. Welcome to the mid-game case management. This is where a series of court reviews really sets the pace and the whole direction of the litigation. You gotta master this phase. And here is a rule you need to burn into your brain. It is non-negotiable. The court's expectation that you will cooperate is absolute. I mean, look at the wording from Section 21. There are no exceptions. That's not a suggestion, folks. It's a command. The court fully expects you to work with the other side to figure out the real issues and sort them out efficiently. The whole case management journey is built around 2 main reviews. The first one happens fast, within just 5 business days, and it's all about laying the foundation: pleadings, documents, evidence. Then, about 2 months after that, the second review kicks in. Its job is to get the case totally trial ready, zeroing in on a final trial plan and locking in those all-important trial dates. The whole thing is designed to just keep pushing things forward. Okay, time for the technical plays. Let's be real, modern commercial cases involve a mountain of information. The commercial list has very specific rules for handling the 2 pillars of evidence: documents and experts. Getting this right isn't just a good idea, it's essential. First step, documents. Forget about careering USB sticks back and forth. Seriously, the commercial list runs on the Objective Connect platform for all electronic filing. As soon as your case is listed, you'll get an invite to a workspace. This is the mandatory system. It's how you share everything with the court and the other parties. It's all about making life easier and more efficient for everyone. Now for expert evidence, the star of the show is the joint expert report. The whole point is to narrow down the issues before you even see the inside of a courtroom. So instead of having 2 experts just talking past each other at trial, the court gets one single document that clearly says, here's what we agree on, here's what we don't, and here's why. This saves a mind-boggling amount of time and money. So how do you get to that magic report? It's a 4-step dance. 1, the key questions are set out. 2, the experts actually have to talk to each other before they write their final reports. 3, they create that single joint report. And 4, at trial, they might even give evidence at the same time, a format called hot tubbing, where they can be questioned together. It's a radically efficient way to get to the truth. But hang on, what about those cases where everything is on fire and you need a decision like yesterday? Well, for those, the commercial list has a special high-speed lane. Let's talk about the fast track. The fast track is, well, it's exactly what it sounds like. It's a super expedited process for things that need to be resolved urgently, like an injunction. But here's the bit you really need to remember. In truly exceptional cases, you can ask to get on the fast track even before you've formally started the proceeding. That's a huge tool to have in your back pocket. So how does the fast track get its speed? It's all in the features. You don't have traditional pleadings, you use concise fast track statements instead. The timetables are, let's say, aggressive.
Disclosure is ruthlessly limited to only what's absolutely necessary. And the court locks in final hearing dates super early. They might even use stopwatch hearings to keep everyone on a very tight leash.
Okay, so you've navigated the reviews, you've wrangled your evidence, and now you are heading for the endgame, trial. Let's cover the final moves in the playbook and talk about the ultimate prize for playing by the rules. Now, before you even think about getting trial dates, there's a final checkpoint. The court will not give you dates without a realistic trial plan. It's mandatory. You and the other side must sit down and agree on the witness order, how long each one will take, and the timing for submissions. Why? The goal is simple. Make sure the trial actually finishes when it's supposed to. And here it is, the big payoff, the reward for all that efficiency and hard work. For any trial that lasts 5 days or less, the parties can expect to get their judgment in about 4 weeks. Just let that sink in. 4 weeks. This is one of the most powerful reasons to be on the commercial list. It gives your client what they crave most, certainty and a fast finish. So at the end of the day, the commercial list isn't just a pile of rules. It's a finely tuned system, a whole philosophy, designed for one thing: efficient justice. Understanding this playbook isn't just helpful, it's fundamental to winning as a commercial barrister in Queensland. So you have the framework. You've got the plays. The only question left is, are you ready to use them?